we'll go ahead and get started. We're in Sioux City, Iowa, on November 9th, and next we're going to be talking about the new advertising rules in Iowa. And doing this program live, and this portion of the program also taping for possible webcast later on. So for the webcast viewers, I'm going to be giving a couple of code words during the course of the program, and then in addition to other things, you'll have to let me know those code words so that I know you're actually watching. But this morning we talked about some of the rules of professional conduct from Iowa and Nebraska. This afternoon we're going to talk about the changes in the advertising rules, kind of a hot topic. Instead here in kind of a border area, probably a bigger deal in like Council Bluffs or the Quad Cities, but here for many years you've been dealing with a situation where the advertising rules were different in two states, and now they're more or less harmonized, but there's still a few little Iowa twists. But as you're aware, until last year, Iowa had kind of the most, probably about the most restrictive advertising rules in the nation. Were at least the black letter law of the rules was pretty limited what lawyers in Iowa could advertise. And the Supreme Court the Iowa Supreme Court kind of saw the handwriting on the wall that if some of these went up to the U.S. Supreme Court, those old ones would be clear that it would be down on First Amendment commercial speech grounds because they're very, very limiting. And just as I was flipping through the student phone book last night, I could see that in many cases lawyers were kind of pushing the envelope and doing things in their ads probably prohibited by the actual black letter of the rule, although not quite pushing the envelope quite so much as maybe in some other states. But things have changed now. Those rules are last year the American Bar Association were kind of soliciting comments throughout the state, getting ideas on what to propose. And then this year on April 20th, on my birthday, they proposed the new rules. They are available online, and I know what happened to my materials. That Twitter link that I thought I accidentally cut out was in blue, and when I printed it, I had black printer and up here. So if you want to find a link for it, if you go to today's program, on my website, I have a copy of the program materials there, and if you download a copy, that will have the link. So if you want to see the actual rules, you'll be able to find them. Anyway, those are proposed, and the deadline for comments was last July. Quite a few comments from around the state. August 29th were the final rule handed by the Supreme Court, and they will take effect on January 1st, 2013. So the new rules that I talk about, and I just had these materials the other day, so I might have missed a few things I might call the proposed rules. But if you see the word proposed rules here, I'm actually talking about the new rules as they will take effect on January 1st. There's one exception to that. In general, the new rules are a lot less restrictive, but there are a few substantive changes. There is a provision that if you have a contract for advertising that was already in place, then you're permitted, with respect to those ads, to continue the old rule for 1 year. So, for example, on solicitations that are mailed out, they changed the language that has to go on the outside of the envelope. I think it used to say advertisement only, now it says advertising material or something. So you won't get into trouble for using the old rules for 1 year, provided that's part of kind of advertising contract you would have been involved with. So anyway, we're going to start out today just by looking at the old rules, just for old next day. And we kind of glossed through them pretty fast. They're only in effect for a couple more months. In most cases, they're probably not enforceable, but I guess a valid CLE topic because they're still in effect for 2 more months, at least in theory. And it's kind of an interesting look back. When I gave this program last year, I gave my ethics program. I did kind of a combined version that included both Minnesota and Iowa and Wisconsin. And so the part of the advertising rules, the other lawyers in the state found very interesting that Iowa was still adhering to these old rules. So it's an interesting look back, even though these will not be in effect longer. Well, Rule 7.1, I guess, probably hasn't changed too much. Well, no, it has changed. Yeah, all these rules have changed. Rule 7.1 says the new rule that we'll get to, which is the same as the rule in other states, says that in any kind of communication you have with the public, you can't do false, misleading information. Probably didn't need to come to the data seminar to learn that. And that prohibition remains in effect. You can't give false and misleading information, not just in advertising, but in any communication. So when you're talking with the reporter about your case, you can't give them false misleading information about your practice. Under the old Iowa rule, and this has been put out now, but you were prohibited from any communication about something that were unverifiable. So, presumably under the old rules, it was a violation to say, well, I'm a pretty good lawyer. Well, because, who's to say, it's kind of unverifiable. That prohibition has been removed. And you were also not allowed to rely on emotional appeal in any case, not just advertising. Or to make any statement or claim relating to the quality of your system. It's just flat out prohibited. Even if you really were a good lawyer, even if it wasn't verifiable, you were not allowed to say that. Or you not allowed to say that I've won most of my cases. Even if that was true, even if it was verifiable, you not make any statement about the quality of your service. So those add-ons are now. The new Rule 7.1 simply says that in your public communications, you can't alter misleading. And the misleading goes kind of far. You have to be careful that if there's some fact has to be disclosed to make the statement not misleading. You have to make sure that you do that. And I guess before I forget, I think if I check these things, before I go on, my first code word for the webcast word, and I guess we'll make first word misleading. So that's the first code word about misleading. Not misleading. So Rule 7.1 still does govern any kind of communication with the public. Rule 7.2 typically focuses on advertising. Still does. Old Rule 7.2, and we'll gloss through it kind of fast. Under the old rule, it basically said no, you can't advertise except some very limited things. The new Rule 7.2 basically says that you can advertise anything, subject to exception. But first of all, what you were allowed to do, what they did say, Rule 7.2 started out by saying the following things are not advertising. Do not fit an addition of advertising. So were always allowed to do the following thing. Communications or solicitation between lawyers. So if, I don't see CLEs as practice of law, but if it was, I could send out any kind of advertising that I want, because that's excluded from the definition of advertising, because being sent to a lawyer. In fact, even if it was legal, I can do research and write for you, or even I can do your personal, bankruptcy or whatever. That was permissible as long as it's soliciting another attorney. It has always been for you to send things that are outside definition of advertising to an existing client, unless that attorney-client relationship has been terminated. And then finally, the last exception, kind of interesting, because, it kind of made sense when the rules were originally adopted, that this is a sensible exception. Communications that are applied to a request for information, member of the public. So if a member of the public calls you up and says, give me information about your firm, it stands to reason that you're allowed to give that information. In the Internet age, maybe a little bit